It's a pleasure to be here today. I see so many familiar faces. It's really gratifying to see you all, and to see you all at this point in your educational career. It really gets better, and it won't be long. You all will be out and in your own practices, and that will be exciting. I am here today to share with us a topic near and dear to my heart, and that is the medical legal, medical ethical issues that face us today as physicians. And as you move through your educational career into private practice or whatever kind of group practice, hospitalist practice, whatever you're doing, these medical legal issues become very, very important. Because these medical legal issues oftentimes are about our wallets. And so we have to be very, very careful, because these kinds of issues can take our wallets and actually set them on fire. So we want to be very, very careful that we adhere closely to these guidelines that we'll go over today. Hopefully, when we're done in this hour, this is like a CME course for you all early on, I want you to be able to understand the concept of informed consent and to understand the exceptions to informed consent. We'll be able to look at the concept of errors in practice, as well as understanding the concept of apologizing, and we'll cover that. And then I want you all to understand, especially being in the hospital setting now, about advanced directives. Irrelevant financial interests in this talk today. This is a question that may be asked. I'm a physician. I treat patients. What is the first thing I should do before treating a patient? First thing that should be done before treating a patient is obtaining informed consent. The reason it is so important to obtain informed consent, both as an ethical physician, we want to obtain informed consent. The other reason for obtaining informed consent is today most malpractice actions result from failure to obtain informed consent. Informed consent comes out of the 1914 case that the decision was espoused by Justice Benjamin Cardozo that every man and woman of adult years and sound mind has a right to determine what shall be done with his or her body. We know the bioethical concepts of Beauchamp and Childress is developed in the 1970s. They gave us, at that time, the new concepts of autonomy, coming from the Greek word autonomos, meaning self-rule. It is out of autonomy, autonomos, that the concept of confidentiality, privacy, and informed consent arise. The other components of bioethics were, and still are, beneficence, do good, non-maleficence, do no harm, and justice, the equitable allocation of scarce medical resources. Before initiating any medication, before undertaking any procedure, it is important to explain to the patient any potential risks or side effects, medication interactions. We need to explain any potential of risks or side effects for not engaging in the procedure. And we need to explain, or at least offer, the potential for alternative treatment approaches. And these have come out of a long line of legal cases that evolved into this new concept. Document that you discussed the above in the chart. Some of you will perhaps still be in practices where charts are written. However, now I know here in the hospital you're using the electronic medical record. Please put documentation into the record that you discussed with the patient. Potential risks, side effects, benefits, and med-med interactions, and or potential risks, side effects, benefits of an interventional procedure, and potential risks, side effects of not engaging in the procedure, as well as potential alternative treatment approaches. Failure to do so may allow for the patient to bring an action in malpractice. So we want to be very cautious about that. Are there ever any instances where it is ethical not to obtain informed consent? And the answer to this is yes. There are 4 areas where theoretically informed consent does not have to be obtained. However, I caution you about exercising any of those 4 areas. There will be one area that you will find yourself addressing in the hospital, especially in the ICU and or in the emergency room on a regular basis. You will see that in a moment here. The exceptions to obtaining informed consent. Again, please, I caution you against exercising any of these. However, common knowledge. A physician is privileged not to advise the patient of matters that are considered to be common knowledge, areas where the patient would be considered to have actual knowledge, particularly on the basis of past experience. Again, the dilemma with this, if it winds up in court, will be the issue, what is common knowledge? The court will usually tend to err on the side of saying that the individual did not have the knowledge or the understanding. So we have to be very cautious with that. The emergency situation, this is imputed informed consent. This is what you will run into in the emergency room and oftentimes in the ICU, in the intensive care unit. There's no duty to inform that arises in an emergency situation, especially if the patient is unconscious. If the patient is unconscious or otherwise incapable of giving informed consent, then the need to intervene to save a life then imputes informed consent. That doesn't mean that we can proceed negligently. So you still have to exercise due care, the care that an educated and informed physician practicing competently would exercise. Therapeutic privilege, professional discretion. Please be real careful with this one. This is if giving the information to the patient would be so traumatic for the patient that he or she would not be able to proceed with his or her care, then one can exercise what's known as therapeutic privilege or professional discretion and not disclose all of the information. I'm going to come back and explain how to apply these. The competent patient who seeks not to know. This is the individual. When we say competent, this means the individual has intellectual capacity to be able to say to you, I am of sound mind in adult years, and doctor, please don't tell me what the potential risks and side effects are. I really don't want to know. I know that I need this procedure. I know that I'm suffering from an illness wherein I need to go on medication. So please go ahead and intervene and provide the care, and we'll go from there. Now, here's the dilemma. The dilemma is when something goes awry, as opposed to pumpernickel. When something goes awry and the individual is injured, now the individual may seek out a plaintiff's attorney, and the individual is going to say, well, I told you I didn't want to know. However, I didn't know you were going to do X, and if I'd known you were going to do X, I wouldn't have said that. So this then becomes a difficult issue, especially when it goes before a jury. What I recommend, if you find yourself in a position where you are very concerned, especially when treating children, and you're concerned about giving them all of the potential risks and side effects, that's where their parents come in. And you discuss this with their parent or their guardian. And you say to the parent or guardian, these are my concerns, these are the potential risks, side effects, these are the potential med-med interactions. How much do you feel comfortable with us explaining to the child or the adolescent? And the parent will then, as guardian, say, let's do this and this, and then you document and chart that. It is the same thing with elder care patients. If you fear that explaining potential risks and side effects will actually traumatize the elder care patient, you want to discuss it with his or her family so that someone is aware that there are these potential risks and side effects, and you document that the family was aware and the family requested you to proceed without going into too much detail with their elder care parent or family member. So please be cautious when exercising either 1, 3, and 4. I recommend you discuss these issues appropriately with family members for so long as you have the permission of the patient to discuss this with the family, so you don't have a breach of confidentiality. Are there different kinds of mistakes in medicine, and does it make a difference which mistake is made? And the answer is yes and yes. There are different kinds of errors and mistakes. Let's look. The two key errors are an error of omission and an error of commission. What is the difference? An error of omission is failure to ask a question. You omitted asking the patient, do you have any allergies? Are you allergic to any medication? That's critical, because prescribing a medication to which a patient has an allergic response, if one failed to ask the patient, do you have any allergies to medications, is an error of omission that is very hard to defend from a malpractice action. So again, an error of omission is failure to do. An error of commission is an action that is inappropriate. You have committed an inappropriate intervention. That's an error of commission. So, an error of omission would be failure to ask about allergies to medications. An error of commission would then be giving the medication to which the patient has an anaphylactic response because he or she is allergic to that medication. So we need to ask, and then we need to be cautious about how we proceed. Assessing the quality of the error. Then we look at the error from a slightly different perspective. We look at it from, is it an error in fact? Is it an error in judgment? An error in fact can either be an omission or a commission. We can, in fact, fail to ask questions, fail to review medical charts, failure to obtain medical charts before we proceed with the patient. That's, again, an error in fact that was an error in omission. And then there can be an error in fact that is an error of commission, where we give a medication to which a patient has an allergy. Now, what about an error in judgment? What is an error in judgment? An error in judgment, we haven't omitted anything. An error in judgment would be, as an example, patient presents, we do due diligence, and we come up with a diagnosis of major depressive disorder. Patient has major depressive disorder. We assess the patient, we assess the patient's past medical history, we intervene and we treat. We intervene and we treat. The patient presents with major depressive disorder that we assess. The patient is showing hypersomnia, sleeping all the time, hyperphagia, eating all the time, and energy, no energy. So we decide that this patient would be a good candidate for bupropion hydrochloride, Wellbutrin, which is excellent for treating atypical depression, which this patient is demonstrating because of the triad of the hypersomnia, sleeping all the time, hyperphagia, eating all the time, and lack of energy. So we prescribe the Wellbutrin. Patient tells us that he or she, bless you, has no allergies to medications. Patient, in doing a relevant medical history, has never had a seizure, does not have seizure disorder. We prescribe the Wellbutrin. We prescribe it appropriately. We start with 150 milligrams of the Wellbutrin XL. Give it a week or two. We increase it to 300 milligrams. And then when we go to the 450 milligrams, which is FDA approved in the package insert, patient has a seizure. And the patient seeks out a medical and malpractice attorney, plaintiff's attorney, and a legal action is brought. And the action is brought because a medication was prescribed and the patient ended up having a seizure with untoward results. This is an error in judgment. The medication that was selected just didn't seem to be the right medication because it led to a seizure. However, was this malpractice? Was this negligence? And the answer is no. No, because how would you defend this? You would bring in a handful of other psychiatrists and clinicians who would, on the stand as expert witnesses, testify, you know, I would have made the same diagnosis based on the same facts, and I would have intervened with the same medication. So again, I would have exercised the same judgment. What happens is the injured individual, the plaintiff, will bring in his or her own expert witnesses, and these individuals will say, well, you know, in my judgment, I would have recommended initiating a serotonin selective reuptake inhibitor. And this becomes then a duel of expert witnesses, and as you all remember from medical jurisprudence and medical ethics, long ago in a galaxy far away that you all have blocked out of your memory, the jury is the trier of fact. And so now it becomes a matter of a jury deciding what they think in their best judgment will allow the plaintiff to win the great American lottery. So this becomes a key issue. This is an error in judgment. You've gathered the appropriate data. In good faith, you've come to a medical conclusion. However, an untoward result ensues. An error in judgment is acceptable if others would have made the same judgment. And it's only an error in judgment in retrospect because an undue result occurred. So please keep that in mind. This is different from an error in fact. An error in fact, patient comes in for cholecystectomy, for removal of a gallbladder, and it is attempted laparoscopically. Unfortunately, the gallbladder won't fit through the small incision, and so now the traditional surgery is required. The individual is opened, the gallbladder is removed. For months, the individual still has pain. Well, we check, that can happen after cholecystectomy. However, an x-ray shows that a sponge was left inside the abdomen. That is an error in fact. So again, that's much harder to defend. In fact, those kinds of cases often fall into another area of the law known as res ipsa loquitur. The thing speaks for itself. Sponges are not supposed to be left inside body cavities. So that's a difficult one to defend. That would be an error in fact. The ethical dilemma. If an error is committed, do I apologize? Do I say I'm sorry? The traditional wisdom was, do not admit an error. The traditional wisdom was, mum's the word. The modern perspective is you apologize. However, you do so with finesse. What is the reason we do so with finesse? The reason we do so with finesse is because there are now laws in 36 states to which we need to be adherent, and yet we also need to be cautious. Now, let me come back. If the error occurs in the hospital, the Joint Commission requires that the hospital disclose it to the patient. So it's going to be disclosed to the patient. So now we as the physician don't want to be chasing behind the stagecoach. We want to be on the stagecoach. So it puts us in a difficult position. For our failure to apologize, now we look callous and rude. And the AMA has long taken the position that a physician has an ethical duty to disclose a harmful error to a patient. Now, several states, 36 to be exact, as of 2018, have enacted so-called apology laws. These laws should mitigate the conflict the physician faces when trying to meet this conflict within us of a desire to apologize and yet not wanting to incriminate oneself. There are two types of apology laws. Two types of laws. One category protects apologies and acknowledgments of fault, admissions of responsibility that go with the apology. Colorado has one of those statutes. You can admit to error and give an apology, and it is not admissible in the courtroom to show liability. The second category protects the apology itself, however, doesn't protect acknowledgement of fault. So if you say, gee, I'm really sorry about what happened, I feel terrible, and I'm just so sorry, that is not admissible in a court of law. If in those states, if you say, I'm really sorry for what happened, and you know, it was all my fault, I shouldn't have done this, then if you're in a state where the apology is inadmissible, however, fault is admissible, now you have just made an admission of guilt, and that can be used against you in a court of law in a malpractice action. So it is important to know the statute in your state. What about the state of Missouri? Because that's where we're all practicing at this moment. Missouri adopted its own sympathy-only type apology in 2005. And I quote, "The portion of statements, writings, or benevolent gestures expressing sympathy or a general sense of benevolence relating to the pain, suffering, or death of a person and made to that person or to the family of that person shall be inadmissible as evidence of an admission of liability in a civil action. However, nothing in this section shall prohibit admission of a statement of fault." Again, this is very specific in what it says. An admission of sympathy or a general sense of benevolence relating to pain, suffering, or death made to that person or to the family of that person. So again, if you make statements to others, that has the potential to be admissible. To family members or to the person, him or herself, it is not admissible. So I just want you to be aware of that. These are the apology statutes. And so when you go forth, and you're out in practice, depending on the state in which you practice, please assess the statute in that state so that you understand the parameters. And again, making an apology for an error is not just ethical, it's just good human practice to do that. But again, check your statute, because you don't want to find yourself in the middle of a malpractice action and having damaged your chances of protecting yourself. If I employ a physician's assistant, a nurse practitioner, or a nurse in my practice, am I responsible for errors that those individuals may make? And the answer is yes, most likely. And this is based on the legal concept of vicarious liability. Vicarious liability means being responsible for the actions of others. Let's look. Vicarious liability. As you see on the slide, it is the principle wherein one person is held liable for the wrongful act of another person. This is applicable to physicians who employ or supervise other health team members that may have less training than the physician. So the greater knowledge is imputed to us, as is the liability that follows with it. Physicians are held to owe a duty to their patients to supervise those within their practice. Now, a lot of this is changing and evolving, as it were, based on state statute and based on the statutes that grant greater practice privileges today to ancillary healthcare providers. Now, this concept, the three main doctrines upon which this imputation of liability to you as physician from others working with you comes out of the concepts of respondeat superior, let the superior reply. That concept of respondeat superior, you're in practice, you're in a family practice, you are needing to give an injection to a patient, and we know that if you're giving a gluteal injection, it's the right upper outer quadrant. If you are giving it in the right gluteal, it is the left upper outer quadrant. If given in the left gluteal, and we were trained in my day, the hand goes here, and you see where that area is. You know to do your injection, and when you do the injection, you go in, you withdraw to be certain that you're not withdrawing blood, and then you go ahead and complete the injection. When I was in residency training in psychiatry, we did all of our decanoate antipsychotic injections ourselves in our own clinic as residents, and so we had to practice and be certain that we were protecting the patient from an adverse response by injecting into the sciatic nerve. That was not something you wanted to do, and we would do Z-tracking as well, where you lift up, inject, remove, and then drop the hand back down, and that helped to seal the injection better into the area. A nurse injects the patient in your practice, the nurse works for you in your practice, and the nurse hits the sciatic nerve, and the patient hits the roof, and the plaintiff's attorney now hits the keyboard, and you receive notice that you're now part of a malpractice action. Are you responsible for the action of the nurse in your practice? Most likely, yes. What is the reason? You are respondeat superior. Let the superior reply. You are the superior, as it were, from a liability perspective. The old theory, captain of the ship, historical in nature, no longer applies, nor does the borrowed servant concept. The borrowed servant concept came out of the theory in years past where physicians would practice in the surgical suite, and they would essentially borrow employees from the hospital to help them in their surgery, and so they were considered the captain of the ship, utilizing borrowed servants, as the term was in the law, and ultimately it was respondeat superior. They were held liable. Should I advise my patients to look to the future and make plans for their health care should they be unable to communicate their wishes? The answer is yes. What is this addressing? This is addressing advanced directives, healthcare directives. And what are these? An advanced directive is a document in which you give instruction, not you the physician, you the patient, you the individual give instructions about your health care, what you want done or not done if you are not able to speak for yourself. Advanced directives don't have to be complicated at all. You will see them here in the hospital. You will deal with them regularly, especially in the emergency room. You'll also have to deal with them on the floors as well as in the ICU. They're short, simple documents that explain what the patient wants to have done or does not want to have done when he or she is in the position where he or she is no longer able to communicate their desires. What are examples of these healthcare directives? Advanced directives are healthcare directives, living wills, or a healthcare power of attorney, a durable power of attorney. What are these? Living wills. This is a document that describes healthcare wishes. Maybe a single page, maybe a couple of pages long, maybe a front and a back. And some of these are just check boxes. It says whether or not a patient wants to be intubated. It says whether or not the patient wants hyperalimentation. And we have to respect these wishes. Now, I'm going to go through the types, and then we'll hit the dilemma of what happens with these. A power of attorney for healthcare. This is a document in which you name an individual who serves as your decision maker. An advanced directive, that term is a combined living will and power of attorney. That says what you want, what you don't want, and it also says, I also appoint my nephew Irving, who will be the individual you will contact to discuss these issues. The number of documents, different states have different perspectives on whether you have one document, two documents. In Missouri, there are two basic kinds of healthcare documents that everyone should have. First, you'll need a document naming a trusted person to direct your health care if you are unable to do so. In Missouri, the official name for this form is the durable power of attorney for health care. The durable power of attorney is a document. The individual is the agent who performs the task of being the durable power of attorney under the document. Second, you should make a document setting out the types of medical treatment that you would like or not like to receive. This is the living will. And so you have both those documents. Now comes the question. That's great. You have both those documents. Where are the documents when you need them? That becomes the key issue. You see this all the time. Individual shows up in the ER, and they may show up from a nursing care facility, and you say, gee, do we have a DNR, do not resuscitate? Do we have a living will? Do we have anyone who has durable power of attorney? And it's like, yeah, I think his nephew Irving is the durable power of attorney. Do we have a document stating that? And they'll go, yeah, we don't have the document. Irving shows up, and you say to Irving, what are you doing here? He says, well, I have the durable power of attorney to discuss these issues. Do you have the document? Yeah, I don't have that. Oh boy, now you're in a fix because you don't know if Irving really is appointed as the durable power of attorney. So, what can the durable power of attorney do? Well, we'll move from this because that's redundant. So here's the real key. Can my durable power of attorney overrule the wishes I have spelled out in my living will? So now you have the living will. A durable power of attorney document has appointed Irving, the nephew, as the durable power of attorney, and Irving comes in and looks at the living will and says, yeah, I want Aunt Matilda, I want her intubated, I want you all to do the blue plate special, I want you to spare no expense and spare no intervention. I want you to put lines in wherever you can put in a line. And what happens is, the reality, a durable power of attorney cannot overrule the provisions of your living will. The role of the durable power of attorney is to supplement your wishes. If something comes up that isn't in the living will, then the durable power of attorney can intervene and say, yeah, in this instance, Aunt Matilda would have wanted this, because that is not spelled out and listed in the living will. And this is another key issue. If the patient, or if you, as an individual, have designated a power of attorney for financial decisions, keep in mind that if you have a durable power of attorney for medical issues and another durable power of attorney for financial issues, they may be in conflict at times. And so you want to be certain that if you select two durable powers of attorney, one for financial issues, one for medical issues, that they work together well and that they understand you well. It's often prudent to just have one person who serves as durable power of attorney for both. Where do you keep your documents? Well, it's important. Many people keep their documents in a safe deposit box. That's great. However, at 2 in the morning, when you get transported to the ER and you show up there, yeah, the living will is nowhere to be found. It's at the bank. You can't get into the bank. The safety deposit box is locked. You are not in the state of being able to access it. You're unconscious. So what's really important is that your healthcare agent has a copy of the healthcare power of attorney, your living will, and a durable power of attorney. And it's also important that patients have these on file, that these are in their charts, that these are in the electronic health record. So it's very important to explain this to patients, because patients are great about listening to your advice as a physician. However, they then don't have the knowledge to know that that document or that authorization has to be readily accessible. So please keep that in mind. Hospital chart, safe place in the home, carry it with you. It's recommended for the durable power of attorney. Keep the document in a safe place, in a briefcase, locked in the car, so that they have it when they have to rush to the ER, they have instant access to it. And there you have it. And any questions, if you have them, please. Probably shell-shocked. Yes, questions.
Is there a role of implied consent in medicine at all?
Yes, there is. And the implied consent especially comes in emergency situations where the individual is in extremis and is not in a position to be able to express his or her wishes. There's no one else there. It is emergent, and so there is a sense of implied consent. However, when invoking the concept of implied consent, please do so with appropriate diligence and due care, so that one is not engaging in gross, willful, wanton negligence. That is not protected by implied consent. Does that answer? Is that okay?
We had an issue recently with all of the news with this doctor from Michigan about can we still use implied consent? For example, let's say a woman comes in for a pap smear, schedule her for a pap smear. Do I need to have written consent to now do a pelvic exam? Or is it implied consent that she's scheduled that visit for that procedure that she knows she's gonna have the pelvic exam.
Okay, and that gets to the question of what is common knowledge? Should a patient know that coming in for a pap smear implies there will be a full female exam, a pelvic examination as well? And my response to that is, we should explain to patients the full direction of the examination and explain to them the potential risks, side effects of having the exam performed, explain the potential risks, side effects of not having the exam performed, because this is Truman v. Thomas. It was a legal case directly on point with this. Patient came in for her annual physical every year, and the physician said to the patient, you know, we really ought to do a pelvic and a pap smear. And the patient said, no, I really don't want to have that done. And the physician said, okay. Ultimately, the patient suffered cancer and expired, family brought an action. And the physician said in the courtroom, well, it's common knowledge. Everyone knows that the female should have a pelvic and a pap smear on a regular basis to rule out the potential for cervical cancer, other types of untoward events, and so it's common knowledge. And the court said, yeah, it wasn't so common of knowledge in this instance because the patient didn't understand the risks of not having the exam performed, and the physician lost the case. So again, it's really prudent to explain. Again, the current informed consent requires us now, coming out of the Truman v. Thomas case, ultimately the extension of that is, not only do we have to explain potential risks, side effects, benefits of performing the procedure, initiating medication, we have to explain potential risks, side effects of not engaging in that intervention. And then we also have to explain to the patient there may be alternative treatment approaches. And it's okay not to know all of the alternative treatment approaches. However, some individuals want to use natural approaches today. So again, they may say, well, you know, instead of utilizing one of those medications that you use in psychiatry, I'd rather use CME or St. John's wort. I'd like to use grapeseed extract to treat my child's ADHD or pycnogenol. Well, that's fine. There's nothing wrong with that, other than it's important to say to the patient, there are alternative treatments. I admit I am not well schooled in those, and there are potential risks and side effects of those as well. Plus, many of those, while researched by Commission E in Europe and approved there, do not have FDA approval here in the United States. And so because of that, I cannot give you full information on that. You may want to go to a health food store and talk to other people, and that's fine. It's important to, essentially with informed consent, to cover all those areas today. It's a lot, I know. Does that help? Was that responsive to your question? Please, other questions? Yes.
Do you have any advice on the current status of like Good Samaritan type situations? Say we're out in the community and someone collapses, and any cautions or
Yes.
any changing that's going on with that sort of thing?
Absolutely, and I appreciate that. States have their Good Samaritan statutes. Please review the statute in your state before intervening, driving down the highway, and you see there's been an accident and you step out to help. One, should you intervene to help as a physician? Number one, it does help that you're licensed in the state where you're stopping. That helps. Number two, one is still held to the standard to perform without engaging in gross, willful, or wanton negligence. The Good Samaritan statute doesn't protect you from gross, willful, or wanton negligence. Failure to perform appropriately is still a standard to which you are held. Now, again, a lot of it is based on the circumstance as well. If you don't have your doctor kit with you, and you need to need to open an airway or maintain a patent airway for the patient due to some type of injury, you may have to take out a pen and remove the ink part and use the shell to open up a breathing passage. As long as you do that within what is considered to be non-negligent guidelines and you're attempting to save a life, yes, you're probably protected. However, I use the word probably because, again, we don't know what the full result will be if this goes to court and if this shows up in front of a jury. So one still has to exercise caution and understand the statute in your state. Does that help? Yes. Sometimes we don't have just straight 100% answers for these kinds of issues and questions. Other questions, if you have them? Yes.
In the case of unknown code status,
Yes.
or presumed code status, is it, I've heard people say that it's in your interest to act on and err on the side of kind of doing more. I say that in the context of, I think in the news recently there was a guy that came in DNR, DNI tattooed on his chest, but even the providers were like, is that an active DNR, DNI? Is that something they got on a whim? Is that a joke? You know, and they struggled with how to deal with that.
Yes, yes, and this is the dilemma. And I sense that it is still prudent to err on the side of saving a life when we don't have the actual documentation that we need. And this is wherein the dilemma comes. And I remembered as an intern here, when I did my internship long ago in a galaxy far away, when it was Kirksville Osteopathic Medical Center, and in my traditional transitional rotating internship, we erred on the side of saving life when we didn't have the document. And that's what is so difficult. Again, my sense is if it becomes an issue then where it goes into the courtroom because family's upset that Uncle Henry was kept alive when they were all chomping at the bit to get his estate, the reality is that we have to do no harm. Prima non carrier, prima non nocere, above all else, do no harm. So we have to intervene to treat. I hope that helps. That was the dilemma with which we have been confronted almost since the beginning of time after living wills were developed. If we don't have the document, if we don't have access to the information to let us know what we legally are constrained from doing, then we have to do all we can to save life.
So like the DNR, DNI on the chest, that's not a legal document?
It's not a legal document because we don't really know, because when that was applied, can it be rescinded? Yes. And so we don't know if it's been rescinded or we don't know if it's been updated. Yes. And then it depends how it's put on there. Was it self-done? Was it, well done? And did it have notarization under it? This is the dilemma. It's not a legal document. And that's what's so difficult.
Witnesses' signatures.
Yes. Other questions, I appreciate that, because that's one of the key questions. Other questions, if you have them. If you want, I thought we might do one or two quick visual demonstrations, if you would like. Case of intuition, we are often asked to intervene and treat, and in the case that was mentioned, we don't know what the tattooing on the body truly means. We only know that that's there. It may be decorative. We have to use our best intuition, and that is, without a legal document, we have to be cautious about intervening to treat. If I may I take the textbook, this case of intuition, may I ask you please just to say stop at any time. I'm just going to have you say stop. Very good. I'm going to have you look at the first word at the top of that page. Please, I cannot see it. Please remember, if you will, and if I may I hand you, Dr. King, the book? I'm going to ask you, please, can you tell us how many pages are in that book?
267.
267. In a paperback book, there are approximately 200 words per page. So if we say 300 pages, 200 words, there's about 60,000 words. I'm going to ask you please to go through the book, if you will. Just leaf through and find a page you like. Once you find a page you like, I'm going to ask you silently in a moment to scan down the page and find a word that you like. Now, I'm going to ask you please for today's purposes to select the biggest word, the longest word, the most letters, the most syllables, because that will make this the most impressive. Now, if you find yourself conflicted between two words, as a psychiatrist I deal with conflict, you may select two. However, have you found the word that you like?
Sure.
Okay, very good. I'm going to ask you please to hand the book back. And so right now, because I looked at the time and I know it's 10 till because of my intuition, and I know that we're probably almost done. Is that right? Do we go forth at about 10 till, or do you still maybe want to get a cup of coffee, a bite to eat, or visit the restroom? We have two words that are out here right now, and I'm going to ask you all please to think of the words, to silently spell the words over and over in your mind. And I'm going to ask first, please do not tell us your word, but I'm going to ask you to share with us out loud the first letter of your word. It is a K. A letter K in and of itself doesn't tell us a lot. It's not supposed to. However, oftentimes when we ask patients how they are, they'll go, okay, I'm fine. So the key is this. You have a word that you're concentrating on, and please, if we get these right, I want you to be excited. You're thinking of a word that reminds us that when we are treating patients and we're worried about informed consent or healthcare directives, advanced directives, we know that we're dealing with patients and their families, and you're thinking of one of the most important members of any family, M-O-T-H-E-R, mother, is that correct? Yes. So we want to be aware that the patient may be someone's mother. So we want to exercise caution. And you're thinking of a word right now. I'm getting a sense of a K and an I and a T and a C, because it reminds us that when we stop along the highway to treat a patient, after having read the Good Samaritan statute, we may have to use tools that are somewhat out of the ordinary, and you're thinking of kitchenware. Is that correct? I want to thank you all very much for giving up your early morning to come in for our presentation today on medical legal issues, confronting today's physician. Thanks. Good luck with everything, and please have a good rest of the day. Thank you.